Suppose A is in possession of property. B comes and asks him to deliver the possession to him. He claims that he is owner of the property. Then C comes. He says, I am owner of the property, hand over the possession to me, I am the rightful claimant. Now, the person in possession of the property wants to deliver the possession to the rightful owner. What should he do? Where two or more persons claim adversely to one another the same debt, sum of money, or other property, movable or immovable, from a third person who claims no interest therein other than charges or cost, and who is ready to pay or deliver it to the rightful claimant, may invoke the provisions of Section 88. Now, what does the Section 88 say? Section 88 says, where two or more persons claim adversely to one another the same debt, sum of money, or other property, movable or immovable, from another person who claims no interest therein other than for charges or cost, and who is ready to pay or deliver it to the rightful claimant, such other person may institute a suit of interpleader against all the claimants for the purpose of obtaining a decision as to the person to whom the payment or delivery shall be made, and of obtaining indemnity for himself, provided that where any suit is pending in which the rights of all parties can properly be decided, no such suit of interpleader shall be instituted. Where two or more persons claim adversely to one another the same debt, sum of money, or property, the debtor can file a suit for the purpose of having the conflicting claims to be decided by the court. So this is called interpleader suit. In order to hand over the possession, in order to deliver the possession, in order to entrust the rightful owner with his rights, the person who intends having no interest in the property to hand over the same, he may file an interpleader suit in the court of competent jurisdiction. Now, how the suit is instituted? The plaint in the interpleader suit is similar as that in any other suit. The contents of plaint are the same. The contents as provided by law are to be in the said plaint, but there should be two or three more things. Plaintiff as a defendant, in order to, as the plaint defines in Order 7 Rule 1, those all contents shall be included in the plaint. Along with those, there will be three more sentences, three more things, three more grounds for the purpose of interpleader suit. Number one is that the plaintiff retains no interest in subject matter, either other than for charges of cost. He can claim the charges of cost and nothing else. So the person who is coming in the court as a plaintiff in an interpleader suit, in the plaint shall state all those things which are necessary for the plaint, and along with those things he shall also narrate that the plaintiff retains no interest in subject matter other than for charges of cost. Number 2, the claims made by the defendants severally. There are more than one defendant. They have separate claims. They severally claim. Each of them says this. The defendant number 1 says that he has this claim. Defendant number 2 says that he has this claim. And defendant number 3, if there is, will say that he has this claim. So the claims made by the defendants is severally, is different. So every one of them is claiming his own right in the property. So this should be mentioned in the plaint, that the claims made by the defendants severally. Number 3, there is no collusion between the plaintiff and any of the defendants. If there is a collusion, then the interpleader suit must fail. But in order to avoid it, he must allege in the plaint that there is no collusion between the plaintiff and any of the defendants. Now when the matter comes to the court has the jurisdiction to ask the plaintiff to deliver the thing to the court, and the plaintiff may be required to pay or place it before the court. Where a plaintiff comes in the court in an interpleader suit and states that he is in occupation or possession or in the custody of anything, money or property, then the court may ask him to pay the same in the court or place the same before the court. So it is discretionary with the court. Where the thing claim is capable of being paid into court, the court may ask him to pay the same. And if it is capable of being placed before the court may ask him to place it. And if the thing can be placed in the custody of the court, then the court will ask him that the same should be placed in the custody of the court. When the party is not ready to pay or deliver, but disputes the title, then it shall not be an interpleader suit. Where a plaintiff is not willing and ready to pay and claims himself to be entitled, or has any other claim which he is intending to create in the suit, or he is displaying anything and is not willing to pay to the court on the pretext that he is owner, he is rightful owner, he has the title, he has the interest, he has the status, he has the character, anything whatsoever he claims, if he claims so, then he cannot file an interpleader suit. In other words, interpleader suit is competent only when he is willing and ready to hand over the property to the rightful owner, to the rightful person, and to the person who is entitled to receive the same. But if he is not willing and ready, then the interpleader suit is not competent. So Interpleader suit is only competent in those cases where the plaintiff is himself coming to the court with the contention that he shall pay whosoever is entitled to receive the same. Now, what should be the procedure before the court? The court may at first hearing declare the plaintiff to be discharged from all liabilities in respect of the things claimed, award his cost and dismisses him from the suit. What does it mean? It means that if the court has sufficient material on the record, then the court may declare that the plaintiff is discharged from all liabilities to the defendants and to the claim, and he will dismiss him, means that the court shall strike him out and the matter shall be decided between the co-defendants. Anyhow, if the court deems fit, it may retain the plaintiff till final disposal of the suit. Where the court finds that there is a sufficient material on the record, and if the court finds that there is admission before the of the parties, suppose plaintiff files a suit that he is in possession of a particular chunk of land and he is ready to deliver the same to the rightful owner, and both the defendants appear in the court and admit that the defendant number 1 or 2 is the owner of the property and number 2 is not the owner, or number 1 is not the owner. One of them is admitted to be the entitled, then the court shall decide the case. And if there is sufficient material on the file, there is sufficient evidence on the file, even then the court may decide the same. Where the court finds that the admissions of parties or other evidence is sufficient to adjudicate the title, it shall decide. But if it finds that the evidence is not sufficient, admission is not available on the file, then the court is to adjudicate upon the matter. If not sufficient, if the admission is not sufficient, if the claim is not sufficient, if the amount is not sufficient, if anything which requires evidence is not sufficient on the file. In the shorter word, we may say that if there is no sufficient evidence on the file to decide the matter, the court shall proceed with the case, shall frame the issues and proceed, and any claimant be made plaintiff. In that situation, if the plaintiff is struck out or dismissed from her, then both are the defendants before the court. Then the court, if intends to proceed further, then shall order that one of the defendants shall be impleaded as a plaintiff and the other as a defendant. So this transposition takes place when the defendant, when the court considers that one of the defendants should become the plaintiff for the purpose of the suit. So in this situation, the court decides the matter and hands over the possession and pays to the person who is entitled to receive the amount or to have the possession of the property. So interpleader suit is instituted when the person intends to hand over or pay and he is not aware of the real person entitled to receive the money or to get the possession. So in this situation, interpleader suit is competent and the court decides the rightful person entitled to get the relief from the court.